Please like, subscribe, and hit the notification button so that more people can get exposed to organized money. Really appreciate it.
Organized money.
Okay, one of the weird things about antitrust law, and we have a show with a with a prominent antitrust enforcer from the Biden administration to talk to us about how it works, is that it's law enforcement, it's policing, and it's not generally understood as policing. And we sit, you and I sit on the center left, and so it's weird to be in a political movement that is saying support and fund the police. And it's equally weird that the Wall Street Journal editorial page, a lot of people on the Republican side of the aisle are the ones who are effectively saying defund the police, the white collar police. But that is actually the argument. I mean, there's exceptions on both sides.
I mean, it's really interesting because if you think about you're watching CNBC and it's like a 24-hour argument for defunding the police, right? Like you go, it's Jim Cramer or Steve Leisman and all of them. It's just show after show after show of why are all these police getting involved in the internal affairs of our white collar criminals? Why are you doing this?
Yeah, that's a very different way to understand it. But I watch CNBC all the time, read the Wall Street Journal, and that is what they're saying. It's never framed that way. And so I think we have a great show where we're going to talk to someone at the Justice Department who has done various forms of prosecution, but ended up running the Antitrust Division, and she's going to tell us about what that was like and how she thinks about the job, as well as how Trump's going to do a bunch of other things like that.
Right. We have Doha Mekki. She worked in the Trump administration's Antitrust Division in the first term, and then was the top deputy to Jonathan Cantor in the second term, and then at the very end of the Biden administration came on as the head of the Antitrust Division. We talked to her about the strategies, the tactics, the approach to this police job that she had, which is policing markets to protect competition. So that's where we're going to go today.
Organized money. Let's go. So welcome, Doha. Welcome to the show.
Thanks for having me.
Okay, so the Jewish mother part of the show, Doha Mekki is, I believe, the second youngest acting assistant attorney general for the Antitrust Division of the U.S. Department of Justice. Pretend I said that with a Jewish mother accent. She holds a BA from Duke University and a JD from the University of Pennsylvania Law School. Very impressive.
I liked it better when you were pretending that you had the accent. Yeah.
Also a medical ethics degree, but you were also, I think, the most important thing from my perspective as a fake Jewish mother is that you were the architect of the Google, actually several Google antitrust cases, and you've also done a lot of work in other, antitrust stuff on private equity, on healthcare, and go on down the line. But you were the deputy to Jonathan Cantor, and then you took over the division. So. Very impressive background in terms of stuff you've done, and we're excited to have you on.
Thanks so much.
So let's start with this. When I talk to architects, I want to get the blueprints out. I want to see how you actually do this, because a lot of people they don't have an understanding of the inner workings of government. They see it as sort of a vague, distant thing that acts on high, but people make these decisions and determinations. And in your case, it's the determination to put an antitrust case together. So what I'd be interested in hearing is how you go through that process. Let's start and just try to walk through it.
Yeah. So first, a huge just sort of disclaimer, which is that the DOJ's Antitrust Division does a lot of different things. There's civil cases, there's monopolization cases, there's information sharing cases, but the Antitrust Division also has exclusive jurisdiction, which means it's the only agency that can prosecute antitrust crimes. And regardless of sort of what it is that the Antitrust Division's prosecutors are doing, it is real police work, and it is super fun. It's the thing I loved most from my 10 years at the Justice Department. And you can get tips and referrals through any number of ways. Like sometimes merging companies have to actually notify the government that they intend to merge.
Right.
Sometimes you get a complainant, a concerned citizen who tells you something that really just doesn't seem right, and you follow up on it and you pull the thread, and it turns out there's something there. Other times you're reading the newspaper or you see an article, right, that piques your interest. And I have worked on cases that came in through any one of those avenues. And what happens is when I was at the DOJ, we would assign a prosecutor typically to follow up, to call the person, the citizen complainant, to call up the lawyers who notified a merger for companies and start to get a composite of like what the potential concern might be. And then you have to make a judgment call, right? Like, do you open an investigation or not? Right. So the Antitrust Division's budget is tiny. It's $233 million to police the entire US economy, right? That's not a lot of money. And so you have to make
Is,
really
isn't it
uh,
like the same amount of people that you had in the 1970s at the agency?
there's actually fewer people today working at the Antitrust Division than there were in 1979. And in
Wow.
fact, the entire US government, like the bureaucracy, such as it is actually smaller today than it was decades ago. And
You
you know,
mean the runaway bureaucracy that is strangling America is smaller today than it was
it
in the 70s?
It is, right? And that reflects some policy choices, but a lot of this like critical work is actually done by contractors who tend to be pretty expensive and work at big companies that are themselves behemoths and sometimes monopolies. But regardless, you have to make informed choices about what it is you're going to investigate. And so when I was really privileged to help lead the Antitrust Division, to help Jonathan Cantor lead the Antitrust Division, and also to help his predecessor, Donald Trump's first head of the Antitrust Division, Macon Delrahim, when he was leading the division, um, you have to make choices. And when we were in charge, we made a choice to go after the biggest, most intractable problems because we had this theory that the American people cannot really like vindicate their economic liberty. And that is what antitrust
Mm.
is about, right? And so the Justice Department is the only institution that can sue in the name of the United States, right? And that always meant something to me. It meant a lot to the folks who work at the DOJ and the Antitrust Division. And so, you decide to investigate something and then you add paralegals. You add, we filed this case against RealPage and a bunch of landlords who actually thought it was a good idea, as we specified in the complaint, to share a bunch of information about occupancy and rental rates and concessions and like all manner of information about apartment pricing. And we included data scientists who helped us do like linear review of code. And so figuring out the right skill set of people to like figure out, is there a problem? Right? Is like what are the facts? And then when you're basically done, you decide, does this violate the law? Right? And if it doesn't,
Mhm.
you need to close quickly because, as you know, there's other problems afoot in the US economy, and you got to move on to those really fast. But if there is a problem, they then put together a really big recommendation memo, and these are dense, and they lay out a theory, and they essentially write up all of the work that the team of prosecutors, economists, paralegals, statisticians, technologists, data scientists, and others put together. And then they go to this part of the antitrust division called the front office, which is the head of the division and their very senior staff to basically say, can we sue? Right? Here's how we want to exercise the government's power. What do you think? And typically, that is a very intensive conversation. Um, there's always an opportunity for companies to come in and, make their case for why an action should or shouldn't be taken. And then you file your complaint.
Mhm.
So that's like the life cycle at like a 40,000 foot level of an
Right.
investigation.
A- And that takes years, right? I mean, that's what you talked about takes years.
It can, unless you decide there's an urgency,
Right.
right? So if there is an urgency, and we felt that very acutely on some matters, you can make a choice to um, add additional staffing, to
Mm.
hire help from the outside, to detail it. Detail, it's this term, like you can get other experts from other agencies, right? So like we were very, very concerned about agriculture when I was there. And so we had a detailee from the US Department of Agriculture to like come in and help us like
Mm.
turbocharge an investigation. And that was really helpful. And so that can cut down years. But as a general matter, yes, it can take years to investigate a matter.
So, how did you hear that there were problems at a company? Well, how did you hear of the company Ticketmaster, and how did you hear there were problems with that company?
So it will not surprise you that there's a lot of confidences that I will protect, even outside of government. I have, a lifelong obligation to protect the confidentiality of, brave folks who tell us things, and also the sort of deliberations of the United States. But there are some problems you can see from outer space, and you know, the Live Nation Ticketmaster problem was not new. It was something, Pearl Jam was talking about this in the 90s. And, you know, again, being very careful, we had heard about some very recent examples of Live Nation Ticketmaster taking its very considerable power over artists, over promoters, over ticketing, and abusing that power. And so we made a choice to open an investigation. And what we found unveiled a story about, you know, a behemoth that had so many choke points in the live music industry. And, that case is ongoing. It's pending in a federal court in Manhattan. And I'm very excited for that case to eventually be tried, right? Although, I'm not there. I have a lot of former colleagues who do great work who are going to
Sure.
take that case to
So,
trial.
but what I was sort of getting at facetiously is, you had the Taylor Swift ticketing meltdown, right? Does that have an impact, those kinds of big events? Does that have an impact on, the choices that you guys make? Presumably, there are antitrust attorneys who have kids that love Taylor Swift, or some of them are Swift. Everybody heard of it, right? Does that have an impact on the decisions that people, in government make?
So let me answer the specific question and then like the broader point, because I think it's an important one. On the specifics of Live Nation and Taylor Swift, we are on record clarifying that we were waist deep in an investigation
Right, right.
before that debacle happened. But it is an interesting point about things that resonate with the public and the importance of public enforcers, which is what we were when we were at DOJ, being responsive to the things that happen on your watch. Like this is hugely important. If government exists in this like tower and you tell yourself, fairy tales about you're doing the work of the people, but you're like disconnected from the people, you're not actually doing your job. And so I believe that people who are entrusted to do the kinds of big jobs that we were entrusted to do have a responsibility to act on the crises that happen on their watch. Right. And so, you could see any number of examples of that while we were there. And again, with a $233 million budget that is tiny, you make hard choices. But it just became obvious that the only thing to do is to go after the biggest problems that affect the most
So-
people.
Can I just cut in for 1 second and just make a point? It's $230 million sounds like a lot of money to most people. It certainly sounds like a lot of money to me. Just to give context, Apple's legal budget in 2018, I believe, was $1 billion. That's just one company. So just to give some context for people who are like, what do you mean? You had $200 million, right?
One company that is being sued by the DOJ, right?
Yeah.
I mean, so like it's not just a random company, but literally one of the companies under that enforcement. So that's funny. Things you can see from space, the Grand Canyon and convenience fees, but you cannot see the DOJ budget from space.
You cannot.
But so the interesting thing to me is, so you go through this whole process, you make these decisions, you make this recommendation memo, and then there's this moment at the end where there is, I mean, I'm sure along the way there is some interfacing with the subject of the investigation, but there's a very particular moment at the end of the investigation. What could you describe to us the last rites?
Yes. So there's this conflict, it's a idea that's thrown around that there's a last rites meeting. And sometimes there's not just one meeting, sometimes it's a few meetings, but you essentially, as part of good government, due process, and so forth, you give companies that know that they've been subpoenaed by that point, their executives have been deposed, they know they are under investigation, and there's a point at which the staff, like the team, will say, "Look, we've made a recommendation to the front office, right? Would you like to schedule a meeting with them?" And
But the front
companies,
office are the political appointees,
the
right?
political
Yeah, okay.
appointees, the
Right.
very senior leadership. I'm sorry, my chip was just removed, and so I'm still like jargony, but I'll try to do better. Uh, so um, you almost always companies will take the opportunity to come in and meet with the decision maker. And they'll often bring in their outside lawyers, right? Companies that tend to have antitrust problems are very, very sophisticated. They hire white shoe law firms and very fancy people who are often very smart and make good arguments in their defense. And they may or may not bring in very, very senior executives. It's not unusual to see the CEO,
Mm,
right? The CFO, the general counsel of
hmm.
these very large corporations. And they essentially say, here's why you shouldn't be worried that the company has a monopoly, right, in this area. Here's why this collusion doesn't actually violate the law. Here's why this merger is not going to harm competition in the future. And it's really an important process for both the government and the a potential future defendant, because it's important for companies to understand what it is that the government is concerned about and have a chance to address it. And sometimes companies come away with a better sense and they say, look, this merger is going to be very difficult to get across the finish line. Maybe we should abandon it. Right. And that's typically a good day, because when you're worried about a merger that you think is going to harm people or markets, you don't want to expend a ton of resources proving up the thing unless you have to, right? Because again, you
Right.
have this tiny budget. And so for deterrence, for management of resources, that is very good. But there's never been an easy antitrust case in the history of antitrust,
Right.
right? Because at the Justice Department, we didn't have an in-house court like some agencies, right, that are designed to have
Wow.
in-house adjudicatory
Throwing
bodies.
throwing shade at FTC right
No,
there.
no, no, no. I love my colleagues at the FTC, but I mean, there's always a neutral arbiter that is not affiliated with the Justice Department
Right.
somewhere else. And again, that's no shade to their in-house
In
adjudicative
my day,
processes,
we
but
didn't have judges in the house. Yeah. Anyway, go ahead. Sorry.
um, but it's hugely informative for the government too, because you get a chance to test out the strength of certain
Yeah.
arguments, and you say, look, I see this document that says you're going to have pricing power, and they either explain it away effectively or they don't, right? You say, well, isn't it true that you say there's nobody's going to enter this space if this merger goes through, right? And again, they either explain it away or they don't. And so it's very, very important to have that kind of dialogue. Um, I've never had like a really, uh, you know, crazy, unpleasant, not polite final meeting, but obviously most companies do not like to be in the position of needing to have that conversation with the government, because it obviously suggests that, some action may be imminent.
Yeah.
Um, so, okay, so these, and also I imagine some of the big, the white shoe law firm lawyers are former enforcers, which is, so sometimes there's an attempt to talk to your maybe former colleagues. But I will get to
Yeah.
that. I want to ask you a question, because you've been in, one of the things I forgot to mention in your bio is that you have worked at the Department of Justice for a long time, and um, and you worked under the Trump administration. You were a fairly high level official in the Trump administration, and and then you became a front office person, Jonathan Cantor's deputy in the Biden administration, and then the head of the Antitrust Division towards the end of the Biden administration. So what can you tell us about the experience of working in the Trump antitrust team? How did they approach building cases? What did you and Jonathan do differently when you were making some of the political decisions? And maybe if I could get you to speculate a little bit about what's happening now. I know there was the HPE Juniper Networks case. There were some arguments around Google and Epic Games that the DOJ had. It's sort of one of the few areas where I think you've seen really substantial continuity across the Trump 1, Biden, Trump 2.
Yeah. So I came to the Justice Department in 2015. Barack Obama was the president, Eric Holder was the attorney general. And about 3 years later, in 2018, I had an opportunity to go work as a counsel to a guy named Macon Delrahim, who was the head of the Antitrust Division under Donald Trump for the entirety of Donald Trump's first term. And that was a really wonderful opportunity because it gave me a chance to focus on a few different areas. I helped build out the labor portfolio at DOJ and also worked on the tech matters. I mean, if you'll remember, it was Bill Barr and Rod Rosenstein and Jeff Rosen who ultimately got very invested in potential abuses by the largest tech companies in the United States and got interested in what they ultimately announced was like an antitrust review of those companies. And
Bill Barr was these were higher ups at the Department of Justice. They weren't in the Antitrust Division.
Correct.
Right?
They were very, very senior in the broader Department of Justice.
Right.
And, in terms of the way you work up cases, it's the same across administrations, right? The very senior political leadership is not out issuing subpoenas, taking depositions, reviewing documents. And so, one thing that I observed across my entire time and working for different administrations is just an immense respect for the work of line prosecutors that, continues day in and day out, in most administrations.
Mm-hmm.
I think that there are currents that started in the Trump administration that continued into the Biden administration and that I suspect we are likely to see in Trump's second term. So thinking about some of the key antitrust cases that Macon filed, I think of AT&T Time Warner, right, which was the first contested merger challenge, vertical merger challenge in decades, right, up to that point. I think of Visa Plaid, right, which was a case about Visa and its attempt to acquire this back-end technology that powers a lot of fintech and is very important for fintech. I think about Sabre Fairlogics, right, which is another, kind of techie digital markets case that really put front and center the idea of killer acquisitions. And that really hadn't been done like in any significant way before. And so whatever you think of enforcement during that period, we indicted the first no poach and wage fixing cases under the criminal no poach and wage fixing cases under that administration. And there were very, I think, brave efforts to enforce the law in ways that had not been done before, right? It was Donald Trump's Justice Department that filed the Google search monopolization case, right? That was tried when Jonathan and I were in charge of the Antitrust Division. But again, it takes a lot of courage to do new things and take on big problems. And I think there are ways in which we tried to continue that effort when we were in charge. We ultimately filed a record number of monopolization cases, right? The most in the last 50 years. We filed a interesting algorithmic collusion case. We filed Packers and Stockyards Act cases, right, which is a kind of competition law that was contemplated to be enforced by the U.S. Department of Agriculture. But we found a path to getting that authority for ourselves when we were at DOJ and trying to file good cases on behalf of growers and ranchers and such. And so it's dangerous to speculate, right? We have a nominee in a woman named Gail Slater, who has not yet been confirmed to lead the Antitrust Division. But I think that Donald Trump made a meaningful down payment on the continuation of robust antitrust enforcement in selecting Gail. And so it remains to be seen what her priorities will be, what her approach will be. She is entitled to do things her way, but my suspicion is that this was a very good selection for all of us who were concerned about corporate power and the structure and competitiveness of markets.
Mm.
So I just want to give a little bit of context for some of the cases that you were talking about. So AT&T, Time Warner, and Visa Plaid, and the SaberLogic case. So it sounds very legalistic, but one way to understand it is every business leader in America in 2018 and 2019 was watching these cases because they determined what their strategy was going to be with their corporations. Could they buy rivals? What were the practices that they would be allowed to do or not allowed to do? And, all of them have lawyers that tell them what the law is. And these cases really shape the law. So it sounds kind of like sometimes it can sound technocratic. We did these cases. We did algorithmic collusion, blah, 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 blah. But it's like business people are operating according to the rules that are laid down by these cases. Like, can they do, the Wendy's surge pricing thing? Is that legal? Like, a lot of the stuff that happens in our economy is kind of downstream from these cases. So I just wanted to make that point. But because I know,
Totally.
David, you had a thought
Well,
question on something.
yeah, I mean, I think a good way to look at that continuity that you talk about is with the Google search case, because that really was the first monopolization case in a quarter century that went to trial. And it was an attempt to use antitrust law in a way that it just sort of hadn't been used recently. And so I want to sort of dig into this as kind of a case study. Um, you know, Given that there hadn't been a lot of cases like this recently, what was the approach to get the judge to understand the urgency and the theories involved?
Sure. So that case probably is not a great example of urgency because it was filed in
Well,
October 2020
that is true. That is true.
and was not tried for another 3 years. But setting that aside, that case proceeded to trial over, I want to say, 10 to 12 weeks in 2023. And we invested heavily in storytelling. One of the sort of issues that we had diagnosed about the way antitrust was proceeding is that not that many cases were going to trial. And so our skill at telling great stories had atrophied. And I think that it's hard to really express fully how important it is to tell generalist judges and juries about why this issue matters to the American people. And that's what we tried to do. We tried to tell a story about power through Google's executives, right? The first witness on the stand was a guy named Hal Varian, who was Google's chief economist for a very, very long time. And he was examined over and over and over again about documents that really spoke to, um, you know, Google's internal understanding of its own power in internet search just by getting default agreements, right? What like with web browser
Hmm.
companies, with mobile operating systems, with uh, you know, phone manufacturers. I mean, just so many different ways of getting pole position right out of the gate. We also tried something a little bit different, which was to put something called a behavioral economist on the stand. So to take a step back, antitrust for many years has been reliant on something called economic testimony. And so it's not just, putting executives on the stand. I happen to think that's very, very important, evidence in a case, but you'd often have to hire an outside PhD economist that's typically trained in a subset of economics called industrial organization, right? And they put together a lot of evidence and try to offer an opinion to the court about whether conduct is illegal or not. And so there's a lot of sway because most witnesses aren't allowed to give opinions in that way, but expert economists can. And so we had that, right? There were many economists who testified in that case, but behavioral economists are different, right? They are not necessarily trained in industrial organization. And we happen to have, in my opinion, a great witness who really explained the human element of what happens when you go open a browser and do an internet search, right? He explained the power of defaults and how the ordinary person doesn't even know how to change defaults on their phone.
So what you mean, like when you open your browser and you like click something you like type something in the browser bar, it just automatically goes to Google.
Yeah,
Right? That's like what you mean. Okay, yeah.
right.
That's a default, right?
Total, a default, right? And so, unsurprisingly, Google is going to say, well, competition is a click away. That was like their theme. And they, say it's not very difficult to change a default. But again, like when we were at DOJ, we're the lawyers for the American people, right? And so you have to like meet people where they are and like describe what actually happens in human terms. And we were very fortunate to have an exceptional behavioral economist who just explained the human element. And you could see in how the judge was receiving this information that he seemed to be relieved to just get a real explanation of how people interact with Google's products and services and internet search. And I thought that was really a good and bold choice that the team had ultimately recommended, that our amazing litigation and trial deputy had encouraged the team to go forward on, and that really came together well at trial. And you can see it just like laced through the opinion in that case.
That's really interesting because, I've actually talked to Jonathan Cantor about this, about how there's really been this expert witness kind of arms race that goes on where more and more money, you talk about the small budget, I mean, millions of dollars are spent on expert witnesses, and often in this very cloistered way, right? Where it's my model versus your model, my economic way of seeing the world versus you, the company's economic way of seeing the world. And what you're saying is that expert witnesses should be thought about more broadly in terms of the expertise that they bring, I guess. Is that kind of what you're saying? Like rather than theoretical things to bring in someone to give the theory, you want to bring in people to give the practice.
Totally. I think that the economics profession, which, I am not a trained economist, I just happen to work alongside a lot of them for many years, they're going through their own kind of conversation about a crisis facing their profession and, their credibility and with respect to the American people. And
is that just because they've gotten everything wrong for 40 years? Is that the issue? Because I don't see anything wrong with that. I kind of like that. I mean, I live in the suburbs of DC. It's very nice here. All the money's pooled. Yeah, I like it. So whatever. Anyway, sorry, I interrupted.
Yeah, look, the point stands. They're having an internal conversation about
that's very
their
nice way to put
credibility.
it.
And so I think what has happened over the last, 4 years when we've thought about expertise, we've recognized that the unique province of expertise is not the economist, right? Which had been the kind of orthodoxy for a very long time in antitrust. That's not to say they are not helpful.
How dare you? How dare you? I cannot. Let's end this. I can't.
We're going to ask our next guest, Jason Furman, about that in a second.
I think that we saw teams that did very, very well when there was diversified expertise, right?
Yeah.
When you had people who were expert in industry, when you had data scientists, when you had behavioral economists, when you had a labor economist, when you had just different kinds of skill sets coming together.
And that's storytelling,
unlock
right?
like what's happening in these markets, right? Because it's not easy. It's not easy,
And that's part of the storytelling, right? I mean,
Totally.
you're trying to
wait
get
a second. Wait, no. Sometimes it is easy. Like obviously the cases are not easy, but the whole Google case is like Google is paying Apple $20 billion a year and Mozilla and all these other companies so that they don't put any rival search engines in as the defaults, right? And it's like the judge had a really sort of reasonable question for Google. He was like, well, if you're so good, why do you pay them $20 billion a year. Why don't you keep that money?
So
And it's like that.
I actually sat through most of that trial, and I'll tell you, I mean, that is ultimately where the court landed. But he asked a number of other questions that again speak to the human element of this, right? He also asked, what are these companies supposed to do? Like if someone comes to you and says, I want to give you a lot of money to do a venture of some kind, sometimes it can be difficult to parse the legality of it, right? And so, you know, when you were thinking about generalist judges who are tasked with calling balls and strikes, you have to make it easy, right? You have to make the question focused on the thing that is ultimately salient when you are an enforcer. But
Right.
again, the other side always has arguments, right? And I know you know this, Stoller, because you have written and talked about it a lot. There has been a buildup of case law that is very defense friendly, right, over
Yeah.
many decades. And so even if we thought we had a pretty good theory of a problem, overcoming these like escape hatches and sometimes seemingly exculpatory narratives that had been like grafted onto the law can be really difficult.
Well, okay, so I'm gonna ask. I get that's true. I like. Okay, yes, it's all very complicated. Blah blah blah. Right? That's true. Um, the world is very nuanced. Now let's rob the poor. Right? That's the general. Um, but like Google was shredding documents. Right? They were like, I mean, at some level, they're like, why are you paying $20 billion to keep your rivals off? And also, you
Why
are
are you
under a
destroying
litigation
everything?
hold,
Yeah.
and you are still telling people to delete their chats. It's like that doesn't look. I mean, that doesn't look good, right? So it's like I don't know. That seems simple to me, but I don't wear
You're
robes.
just a caveman.
Right, I'm
So
just a
Sure.
kid. But
But can
here's a question for you. Okay, so this I actually have a question. So, um, you expect the opposition to fight with everything they've got, right? Of course. Did anything like surprise you either from this case or kind of any other case? Like, what's the most surprising thing that you've seen kind of coming out of left field from when you're in a fight?
I think that the willingness of, often well-intentioned decision makers to entertain arguments that are sort of counter to like the human experience of certain markets is sometimes surprising. Um, you know, Fighting against deep-pocketed adversaries is not for the faint of heart. Like it is a contact sport. And there are companies that don't sort of view antitrust enforcement as law enforcement, right? As police work. They can make it extremely personal. And I never felt like it was personal when I was enforcing the law. I felt like my job was just to decide, like, is there a violation of law here? But that's not always what you receive on the other side. And so there was a a vitriol sometimes, not all the time, but sometimes that sometimes surprised me.
hmm. So, spoiler alert, you won the case. The Google case was successful, at least at this phase, the liability phase. And we haven't seen the remedy phase play out yet. So that remains to be seen. But do you think that this victory had impact beyond the particular case as a lesson that these monopolization cases can be brought by the Department of Justice? Not just that they can be won, but just that they can be brought, and that that conduct is on the radar screen of the top enforcers in the country.
Absolutely. I think it was resonant with the public because, many people had commented in, magazines and on podcasts like this and just sort of in the open internet about how the quality of internet search had come down, right? This feeling that people didn't really have options. And so, you know, so many years after Microsoft, right? Because that was the last time the Justice Department brought a big, a big landmark monopolization case. And that was filed in 1998. To then win the case 25 years later was sort of proof of concept,
Mhm.
right? The first being the first lesson being that the government could bring a case like this against one of the most well-resourced companies in the world and win, right? That was very important. Um, it showed that, digital markets and the open internet were in fact subject to the antitrust laws, right? And there are some people who will quibble with that and say, well, of course, and cases had been filed and all of that. But I did a deep dive on a lot of these issues when I was counsel under the first Trump administration. And I looked back through legislative records and saw these like floor debates about like whether we should regulate the open internet, right? And so um, a lot of discussion about how we shouldn't regulate the internet if we expect it to grow. And there are folks like Orrin Hatch, among others, who said, look, don't worry about regulation. There will always be antitrust. But of course, these problems really calcified for many, many years before there was meaningful antitrust enforcement. And so, again, going back to first principles, that antitrust would ultimately do a better job of opening up access to markets and making sure that they're working properly, that they're innovating, and that we are, as a people, continuing to benefit from these technological breakthroughs that make the American economy the envy of the world was very, very important. And then finally, I think there's like a broader point about democratic accountability, right? The Justice Department is a public institution. And, you know, in the last several years, even before Joe Biden was elected, I think there was low faith in our democratic institutions, right? A sense that they weren't working well for ordinary people, right? That the most powerful were getting away with abuses that the ordinary person or a smaller business could not get away with, right? And you see that in a lot of agencies, right? That you were seeing government actors bring to bear the full weight of the United States on these smaller companies, but not bigger companies that, through potential law breaking, were affecting a much broader number of people and were having deeper, um, you know, negative consequences on people's participation in our market economy. And so I think that was very important too.
Yeah, I mean, I talked to somebody at the different agency, the FTC, who said that, before this last administration, they didn't kind of weight concerns by size. They didn't like try to go after bigger companies more. They were just like, what does size have to do with any kind of with antitrust or prioritization, which is kind of mind blowing. But I wanted to, there's a couple of questions. So you're kind of like, there's a generational turnover that I think is happening in society kind of writ large. And I think you're part of that in terms of bringing a new or different perspective. So your unique perspective, like what did you bring to antitrust that previous antitrust division heads didn't? Everyone brings something different. And then I want to highlight something that happened to you that I think really reflects kind of the difference in attitude that big business had and the antitrust bar had with you guys versus the earlier antitrust divisions, going back in a bipartisan way, which is that one of the last things that you did was sued the private equity kind of original private equity OG KKR, which is a $600 billion firm started in the 1970s for allegedly serial lying to the government through documents about mergers. And then you got personally sued by them in your capacity as the AAG, right? What perspectives did you bring? And then what was it like to be sued by such a powerful company? I think you might have been the first antitrust division chief to be personally sued, but I'm not sure about that, but it certainly hasn't happened in our lifetimes.
So I'll take those questions separately. So in terms of the generational shift, I think it's also very interesting. Like you guys, I spent a lot of time thinking about populist currents in our politics. I'm a huge nerd and reading everything I can about the new right because there's elements of that reflected in the current Trump administration. And what I see is, an older um, generation of Americans who more or less adopted this idea that, like, the government using power to structure markets is like inherently bad. Like that is like a mindset that I think is shifting. And I
Mhm.
see it on the left and on the right, right? I see progressives who want to use the power of the state to structure markets. And interestingly, um, there are many on the right who see the world that way, right? Like, regardless of what you think about what is happening now, right? Like, they are using the power of the state to structure markets in certain ways. And they're not necessarily making choices that I would make, but that is what they are doing. And that is a break from traditional conservative orthodoxy, right? Like, that is not what the classical liberals or like the neoliberals think is like a good way to use government. And I spent a lot of time talking to the left and to the right when I was in my role. So I went to the Federalist Society, which you guys know, but is a very conservative legal organization, and is
Mhm.
kind of in the heartland of the conservative legal movement, and often was able to find a lot of common ground and concern about how markets were operating. I was invited to guest lecture in a class, the title of which was like conservative, like modern questions and conservative legal thought. And
Hmm.
I was shocked because in a class of roughly a dozen self-described conservatives, you know, almost all of them agreed with my worldview about what antitrust is supposed to do. And that is to say, they believed in antitrust enforcement, right? They had a lot of critiques about something called the consumer welfare standard, right? And I thought that was interesting. And over my 3.5 years in my role, I saw that younger people were just more interested in a populist approach to governing and political economy. And I think that, we can debate the reasons for that, but it doesn't surprise me that folks who really kind of came of age between the financial crisis, where they probably watched their families lose a lot in terms of like savings and assets and values, and then, the other bookend of the like demand side, market crisis that was ushered in by, COVID, um,
Mhm.
have particular views about how markets work and probably have concerns because they can't afford housing, right? It is expensive to get educated, right? And if you feel your economic opportunities slipping away, it is going to bleed into your political views about how your elected officials and their appointees that lead executive branch agencies should be using their power. And I think, as a relatively young person, like, I'm kind of a washed up millennial, so I'm not that young, but like I saw that, and ultimately was encouraged because I could hold hands with folks on the left and on the right and speak to antitrust in a way, again, always making decisions on the facts and the law, but speak to antitrust in a way that was resonant for people of all stripes.
I want to follow up on that because, you talked before about getting out into the country, being, Jonathan Cantor told me that his client was the American people,
Yeah.
and bringing them into the conversation was clearly a big focus of your work. But I'm wondering if you feel like the impact was made clear in the public mind. Like, it's hard to sell people. We stopped a lot of mergers, like the benefits
Yeah.
of things that don't happen, right? Uh, and I'm just wondering if you think that Americans took away what they needed to take away, because there are a lot of polls that show, oh, I didn't even know that the administration was doing that. And there are a lot of reasons for that, communications reasons and things of that nature. But, you know, how should Americans take away the perspective of this work?
Yeah. So, like every other person who's sort of left leaning, a Democrat, whatever, we're all thinking about this, especially in the wake of the 2024 election. And there are some people who think there was a messaging problem, that we didn't do a good enough job of explaining what we did. And that might be part of it, but I think that largely misses the point. I think that to really improve these, structural problems in markets like housing, like food and agriculture, like healthcare, it's not going to be enough for the DOJ's Antitrust Division, which I have to say, like 800 people in a department that when I left was 130,000 people, right? That's the DOJ, which includes the FBI, and the FTC, which is about 1,100 people, right? These like two relatively small parts of the government doing what they are supposed to do, like antitrust enforcement, filing cases alone is not a really great short run solution for fixing markets that have been hobbled by concentrated power, monopolistic abuses, price fixing, frauds, and so forth. It takes the entire government. It means that HUD probably needed to do more. It means that HHS needed to do more, right? And there are bright spots. There are these great stories.
God, that sounds like so much work.
But there are bright spots, right? Like I was really encouraged by Pete Buttigieg's leadership of the transportation department, right? I was really encouraged about some specific actions that the U.S. Department of Agriculture took, but you need everybody, right? It has to be like a governing.
And you worked in concert. You worked in concert with those agencies in some ways, and that was intentional. Like the whole idea was that we want a whole of government approach, and sometimes that succeeded. But I also remember a USDA employee testifying in a case on the other side of you in a case that you guys brought up, a sugar merger. Well, so it seemed uneven, but is there more to learn from that?
Absolutely, which is that we all need to be better experts on the markets that we are entrusted to protect, right? And again, for HHS, that means HHS is running Medicare and Medicaid. Right? Like, there are well-documented problems with the health insurers, but ultimately HHS structures those markets, right? And so the government actually has a ton of power over how those services are ultimately delivered and what companies are allowed to do because it's footing the bill, right? But that mindset is not necessarily one that has pervaded Washington, right?
So your budget was $230 million. The budget for the part of the health department that controls Medicare and Medicaid is $1.9 trillion. So you're saying that the people with the trillions should pay attention. Is that your basic? That's
in a nutshell.
Okay.
In a nutshell, right?
That sounds crazy to me. All right. So a slightly kind of different question, which is about the cost, right? The personal cost and professional cost of addressing concentrations of power. And I heard this from many people in the administration or in the Antitrust Division in the FTC who are civil and front office. One of the things they say happened is there was kind of a climate of collegiality prior to the Biden administration when you would, when the last rights, even the last rights, or when they'd come in and be investigated for a merger or whatever it was like chummy, and we'd say, how can we help you get this deal through? This little piece is illegal, so we'll do a little carve out here. If you sell that division, we'll get it through. And we're all on the same team here. We're all trying to help you follow the law. And there was like antitrust enforcers were more facilitators of deals than they were law enforcers. That's how they saw themselves. That's how the political leadership wanted them to be. That's how antitrust was understood. There was no monopolization cases because that would be crazy. Well, why would you? Monopolies are not a problem, that kind of thing. And then you guys came in and there was a cultural change, as well as, you laid down, you said, we're going to bring back monopolization law. We're going to file suits against a whole bunch of companies. And you did, and one of the consequences is that the private bar is now running with monopolization cases and actually winning those in some cases. A big deal, right? NASCAR, Epic Games, Epic Systems, like a whole bunch of weird stuff's going on. But one of the changes was about how enforcers were no longer collegial. You were no longer chummy. It was sitting down and saying, we're either going to sue you or we're not going to sue you. We're law enforcers. And that had consequences in terms of the revolving door, in terms of your ability to, I'm assuming it had consequences. I don't know. I wasn't there. But, it was really institutionalized, this shift from the government to dominant firms. And it's not necessarily a bad thing. It just was a thing that was happening. So John Roberts' wife, this is a story that came out in the New York Times. I don't think a lot of people know it, but John Roberts' wife, the Supreme Court Chief Justice John Roberts, his wife runs basically a headhunting shop for ex-government lawyers where she recruits out of the government and places them into big law firms, including antitrust lawyers. What is it like to have challenged all of these powerful firms and then come out of the division into a world where, everyone's kind of mad at you, right? And they see that you did a really good job. And I don't want to say it. I'm just like, but that's kind of a different way to put it is, like, have you figured out the Starbucks you're going to work at? That kind of thing, right? Like, what's it like? I mean, you have to consider how much you're making people angry, and you did the right thing. You were working for the public, but there's a cost on the other end that other people didn't want to pay, but you did want to pay that. And how do you think about that?
Yeah, it's a fascinating question, right? Today is February 11th, right? We're talking on February 11th. I left the government on January 20th, and I have not thought one iota about what I want to do next, right? Like the first thing I wanted to do is take a nap, right? After 3.5 very intense years. And so I don't totally know the answer to your question, or I can't bring like personal experience to this question. What I can say is that yes, there is a cost to angering very deep-pocketed firms, right? You know, the largest tech companies, for example, have their tentacles in a lot of law firms, right? And it can trigger a lot of like conflicts of interest, and having filed like seismic cases against companies that do a lot of things and rely on a lot of outside firms can probably curtail your career opportunities. That being said, I think it is very important that anybody who decides to take a role like the one I did, like, Jonathan Cantor's role, like Lena Khan's role, right, to lead these antitrust agencies, be able to do so thinking only about the American people and doing so without fear, right? Because fear operates on people. I don't begrudge anyone for wanting to make a dollar. There is nothing wrong with wanting to have a good life for yourself and for your family. I think, though, that when you are an antitrust enforcer, you have to stand in for people who are not in the room, which is to say people who live in the Mississippi Delta, people who live like the ranchers in Wyoming, the McDonald's worker that is hampered by a no poach agreement and is suffering all kinds of like workplace abuses because they can't move. And so you have to be willing to absorb all of that for them because that is the job. And so are there personal consequences? Are there limitations that you're probably going to face? Absolutely. I mean, you asked about getting, I did get sued in my official capacity. That is a pending case. And so I won't say a ton, but, deep-pocketed companies do not take enforcement actions lying down, right? They spend a ton of money in terms of lobbying dollars so that they get to pick their enforcers and regulators, so that they get their preferred form of regulation, if there's any regulation at all, right? Like this is the real world in which we operate. And so I would not recommend doing these jobs to make a lot of friends, right? It's to do the right thing. And so I'll let other people speak to, what opportunities are like lost or obtained, but I felt like I could always sleep at night. I made it a point to be polite and courteous to people, even if I had a spine of steel about the decisions that I made when I was an enforcer. And it is an unfortunate fact that companies facing these kinds of actions can make it extremely personal and extremely uncomfortable. But again, I think that is a fraction of what the American people feel on a daily basis. Like I thought somebody described just like doing anything in the market as like an obstacle course, right? Like changing your health insurance, like getting a new prescription, enrolling your kid in schools. Like I need like 10 apps to engage with my kid's school, right? Like thinking about what kinds of like information those like apps are siphoning off, like it is really like dizzying, right? And I'm not someone to feel sorry for, right? Like I was a federal antitrust enforcer, right? Like I am overeducated. I'm again not someone to feel sorry for. And so you just think about like what the American people are facing, and it's just on that telling, who cares if you don't get hired to go do some fancy thing at some fancy place, making probably too much money.
Well, the good news is I think the good news for you is I think Starbucks has a program and they'll help you with that litigation from KKR. I'm pretty sure they got a nice program. It's a small deduction from your paycheck. But I want to talk a little bit about the future because obviously you were at the Justice Department for a decade. The new Attorney General, Pam Bondi, one of her very first things that she did was she sent this memo saying that all attorneys must zealously guard the interests of the United States and that the interests of the United States are defined by the president. And I want you, as someone who has worked there, to tell us like how big a departure that is from how the department has traditionally viewed itself, and what should concern us about what seems like an entry of severe politicization.
This is a fascinating question, and I think this will be an interesting next term to observe the potential limits and expansiveness of what's called executive power. So let me back up and talk about Nixon and the post-Nixon reforms at the Justice Department. The Justice Department it's a Reconstruction institution, right? Like the role of Attorney General of the United States has existed since the founding, but the Justice Department itself was established, I think, in 1870. During the presidency of Richard Nixon, everybody knows, he tried to put pressure on various very, very senior officials in the Justice Department. And like one by one, they all quit rather than carry out the will of the president. And
except Robert Bork.
Except Robert Bork.
I'll do it.
After Nixon resigned in shame, a guy named Ed Levy was the first post-Nixon Attorney General of the United States. And he implemented a lot of reforms and stood up what eventually became a norm, right? And I just want to focus on like norms because they are different from laws. They're different from the Constitution itself. Like they're traditions, right? And so they're only in effect if people are willing to sort of like continue them. But there was a tradition of independence that grew up that sort of put the White House, right, which is on the other end of Pennsylvania Avenue, at odds from like the Department of Justice, right? And so that basically meant that the President of the United States could not call up the Attorney General and say, I want you to open an investigation against, this company or individual. And I think we saw in the last administration that there was a very intense wall, like a very tall wall that grew up between the White House and the Justice Department. But during the pendency of the Biden administration, there is a Supreme Court case that came down, and the details of it are not hugely important, except that there is language in that opinion that essentially says, of course, the president can direct the actions of their Justice Department. And it flows from this theory of the unitary executive, right? So like
Mhm.
the Constitution itself in Article 2 lays out the powers of the executive branch, and the president is the head of the executive branch. And so the theory is that executive power means that the president can exercise all of these authorities. And so it remains to be seen. Actually, let me back up. This is a huge departure from the Justice Department that has existed over the last 40 years or so, right? Because these post-Nixon reforms were very closely guarded, touted even for, legitimacy, the virtues of this democratic institution. And so we're operating in a new era, and it remains to be seen how the White House and the Justice Department will use these authorities that the Supreme Court seems to be saying are completely constitutional.
Yeah.
I am actually a fan of that. I mean, it's the FTC Act 6D, I think, says that the president gets to just tell the FTC go and investigate that company. And Congress can pass resolutions saying go investigate. That was Teddy Roosevelt, and clearly the president has some role in setting policy. If they're going to restructure Google or whatever, if the president comes in and says, this is what I was elected and this is what the public wants. Clearly that's different than saying use antitrust to go after my enemies. Right. So there are
Totally.
different it's not like I'm worried about liberals just screaming, oh, we must keep everything independent.
Totally, totally. I mean, this is hugely important. I actually worry that this is part of the legitimacy crisis that I think the Democratic Party is having to sift through at this point, right? Like, screaming about norms as people are suffering is not like a really good way to build back trust with the American people, right? There are people smarter than me who focus on like political theory and political science, who may well have a point that the American people would have preferred that their duly elected president of the United States would have used that authority to make life better for the American people. And again, I sort of, it's a new administration. They're entitled to govern in ways that are lawful. And we don't know what it is that they are going to do with all of that power just yet. But I think all of us who are, sort of center left, on the left, progressives, like whatever, need to be comfortable thinking about like real governing and like interest in policy and the president's authority to set the policy of the United States and to kind of set the agenda for the executive branch agencies that only exist, at least in the constitutional structure, because there's a president that is vested with all of that power.
Yeah. All right. Well, look, Doha Mekki, neighborhood barista, and former head of the Antitrust Division of the Justice Department. Thank you so much. I learned so much here. Thank you very much for being on Organized Money.
Thanks for having me.
Organized money.
I enjoyed that a lot, but I think there's a lot to chew on. But one of the things that I think we really have to think about as liberals is how much we overemphasize norms.
The norm fairy.
The norm fairy. Right?
The idea that you can't just do that. Somehow that has lost its power, especially in the first few weeks here of the Trump administration. The wagging of the finger and saying you just can't do that. That doesn't seem to work very well.
How dare you? Right? I mean that's the whole Merrick Garland boomer mindset. I mean, not to get ageist, I'm not trying to get there's a certain sort of culture of the legal elite of that age where they think everything has to be done in ways that are just sort of, an oracle, like we are disinterested oracles and not human beings.
Right.
There are norms saying that within 3 months before an election, the Justice Department can't do anything for fear that the voters might notice that they have an elected government. There's all of these crazy norms, and
Right.
and then you're going to see that there's a lot of things that Trump is going to do that are lawful and bad or lawful and fine. There's a lot of things he's going to do that are not lawful. But what I fear is that, a lot of the screeching that's going to take place against Trump or the opposition and criticisms are going to be about the things that he's doing that are lawful, but maybe violate norms, like saying that he has a role with Federal Reserve interest rate policy, which is completely reasonable.
Right.
Right.
The problem with Trumpism is not you didn't fill out the wrong form. It's that
That's right.
You're trying to delete Congress and the judiciary as co-equal branches of government.
Right.
That's a norm worth keeping. We're going to have to sift through, I think, what are the norms that are actually legal codes by which we can run our lives without being an authoritarian state, and which are just filling out the wrong form.
Yeah, like to put it slightly differently, I would say there's hurting a lot of poor people and middle class people so that your buddies can make money, and there's using the wrong salad fork.
Right, exactly. Yeah, so we're here to sift through which one matters and which one doesn't. But next week we have actually a really good show. It's all about utility markets and the ways in which private utilities are recouping massive amounts of money off the backs of ratepayers relative to public utilities. We have a guy, Mark Ellis, from the American Economic Liberties Project. He's going to come in and talk all about it.
And it's all about norms and the emperor's new clothes. It's like Revenge of the Nerd. It's like the craziest story about why we're overpaying and why everything is messed up in the utility space.
All right, check that out next week on Organized Money.
Organized money.